Good afternoon to anyone watching now or in the future. My name is Shannon Cunningham. I'm an attorney at Legal Aid Service of Collier County. And today, in honor of Veterans Day, being tomorrow, we're going to be discussing the services and what issues and what services we can help veterans with in Collier County at our Legal Aid office. So let me start with the disclaimer that I am an attorney. I'm a lawyer that with Collier County Legal Aid Service of Collier County, I should say. I'm going to be giving you some general information about veterans issues and services. Please do not interpret this as legal advice. I'm providing you with general information at this point, and it's for informational purposes only. If you decide that something I've said is something that might help you, you can consult a lawyer and get specific legal advice based on your situation. I'm an attorney, but I'm actually not your attorney until we enter into an agreement between you, I, and Legal Aid. So that being said, what are we going to talk about today? First of all, I'm going to give you a quick overview of the VA, the Department of Veterans Affairs, just generally what they are, where they came from, just quickly. Next, we're going to discuss who actually is a veteran. I know that sounds kind of silly, but there are some legal definitions of who is a veteran and what that affects. Then that issue can affect what you actually are eligible for. We'll talk about benefit eligibility. Like I said, that's part of it. And we'll talk about discharge status, which is, the status of veterans when they leave the military. Were they on good terms? Were they on bad terms? Things of that nature. Then we're going to talk briefly about the types of benefits that are available from the VA, to include, direct veterans benefits and those that could possibly go down to a spouse or surviving child or someone other than the veteran themselves. We'll speak briefly about what other services besides that aren't directly related to the Veterans Administration or the government per se, what we can do to help you with anything else. And then last, there'll be some resources posted on a slide for veterans that they can use to maybe help find assistance of various kinds. So first of all, overview of the Veterans Administration. Okay. Historically, the VA has been the Veterans Administration. In the late 80s, around 1989, I believe, under President Bush, the VA, the Veterans Administration, was elevated to a cabinet level department in the government, in the executive branch. And so it got a little more power and a little more prestige. And it was renamed as the Department of Veteran Affairs. The VA nickname has stuck. The organization actually, the laws that created this were in place in 1988 under President Reagan, but then really didn't take effect until 1989 when he was out of office. At that time, around a third of the population in the United States was eligible for veterans benefits. I know that sounds like a lot, but you have to remember that it isn't just service members sometimes that are eligible for benefits. It could be spouses, it could be small children, it could be a number of people. So, and we have a large, around that, back in the 80s, we still do have a large, population of veterans who served in World War II, Korea. So there are a lot of people. In the past, many of the veterans programs were spread around in different government organizations and agencies, and there was a need to consolidate them into a cohesive area. And through consolidation, the VA was able to condense their programs that they oversee into basically 3 departments, and that's what has formed the modern Veterans Administration. And in today's VA, there are 3 components. There's the VBA, which is the Veterans Benefits Administration. It handles claims, benefits claims and appeals, and it determines eligibility for all benefits. There's also the Veterans Healthcare Administration, and they handle the healthcare services provided to veterans. Then there's Cemetery Services, and they handle things related to burial benefits and national, cemeteries of that nature. So, who is a veteran? Now, there are two definitions of a veteran, and one is a state definition, and one is a federal definition. The federal definition is this, and it comes from Title 38 of the United States Code, and it says it's a person who served in active military, naval, or air service, and who is discharged or released under conditions other than dishonorable. So that includes a lot of people. It's very broad, but in Florida, the Florida Constitution has defined a veteran, and they define it slightly differently. And they say it's a person who has served in the active military, naval, or air service, and who was discharged or released under honorable conditions only, or who later received an upgrade discharge under honorable conditions. So, as you can see, the federal government says as long as you weren't dishonorable, and the state government says you have to be honorable. It's a little bit of a difference, and it does come into play. Basically, on the state level, you can miss out on some benefits at the state level that the programs from the state of Florida only provide if you don't meet that definition, but you would still be eligible for the federal benefits. Okay. So, are there eligibility requirements for benefits? And does your type of discharge matter? And obviously, from reading the definition, you can guess that it does. From the definitions we just talked about, you can guess that it does. So, like we said before, other than dishonorable under the federal, has to be honorable under the state. They only take into consideration, in the state of Florida, they only take into consideration what is listed on what's the veteran's DD 214. So your discharge document, that's what they look at clearly and solely. The federal government does things a little differently. The federal government can do an administrative process that's called character of service or character of discharge determination. So you might be eligible for programs even though you don't have the correct discharge. And like I said before, Florida, implications of what you might miss out on. There are requirements for veterans treatment courts, state education benefits, and some other state programs that might be eligible to veterans, particularly things such as tax benefits. So for things such as housing or your other thing, such as housing or property taxes. Things to consider about discharge from the military. Your character of service, like we discussed, what type of discharge you had. The length of your service is going to be important. If you were if you left the military due to a disability that occurred in the military, or did you go all the way and go to retirement? So, character of service, or what is also called character of discharge. There are several categories here, color-coded for the best. Green is obviously good. So up there you have honorable, and the next you have general under honorable conditions. Then you have what's called other than honorable. It's called OTH. That's kind of in the middle. It's not good, but it's not bad. It's meh. Then next is bad conduct discharge. And of course, the very worst is dishonorable. Obviously, either of these two in the red down here have extremely bad effects on benefits. There's also a category that's called uncharacterized or entry-level separation, which generally occurs when someone was in the military for a very short period of time and they really weren't there long enough to characterize their service. A lot of times this happens if somebody joins up and then fails out of enlistment training, boot camp, that kind of thing. Okay, so we talked about character of service and how you want to be, in the green. Now we talked about length of service, and the government has set in the Code of Federal Regulations, the Chapter 38. It is involved with the Department of Veterans Affairs. It establishes a minimum active duty requirement for benefit eligibility. Basically, it says you have to have 24 months of continuous active duty, or the full period for which a person was called or ordered to active duty. Meaning if you were a reservist or you were recalled, that you fulfilled that period completely. The length of service requirement applies to veterans who enlisted after September 7th, 1980. Those who enlisted prior to this date only have to have completed their initial enlistment term and not been released under dishonorable conditions. You don't see as much of that anymore. It's more rare for that to actually pertain to our veteran clients. The general rule is, to get a VA benefits, including healthcare, is you have to have an honorable general and you have to have served at least 24 consecutive months of active service. Those are your general rules. There are some common exceptions. Like I said, if you enlisted before September 7th, 1980, there's that rule exception, kind of rare. The veteran discharged due to a disability, the length of service can be waived. And if the veteran is already receiving compensation for a service-connected disability, then they're eligible for, then that can waive their length of service. So if you went in and you got disabled very quickly, or within your first enlistment and you were forced out due to the injuries, you can waive that length of service problems. Again, it's important to remember character of service. It's very, very important. Honorable in general, you're pretty much good for everything. I think the GI Bill requires honorable at this point. Other than honorable, there's some leeway to get benefits, but a bad conduct discharge or dishonorable, you're likely not going to get benefits. Speaking of the other than honorable discharge, this is where a lot of clients come in and they're in this situation where they received another other than honorable. It's not the death knell. Basically another than honorable was an administrative discharge suggested by the Armed Forces Command, whichever branch the person was serving in, that they be removed from service due to some type of misconduct. It could be, in lieu of having a court martial brought against them. It may have, you're obviously, you can have a hearing, but most of the time people waive that. The veteran's gonna have to sign an acknowledgement. They're gonna know that there are potential consequences for receiving the other than honorable, which include possible denial or loss of benefits from the VA. And, like I said, this is often started by the command for serious misconduct or repetitive misconduct that they've tried to, rehabilitate you, they've counseled you, punished you, and you just continue. So how do you overcome an other than honorable? Well, it acts as a scarlet letter. It's a mark on your record. and it can prevent you, like we said, from receiving health care and other benefits. However, before the VA, if you have an other than honorable, before the VA denies your request for benefits, they have to review your entire military service record and determine whether the discharge is honorable or dishonorable for VA purposes. So they're not, they're not going to go back and change whatever it says on your discharge or on your DD 214. But what they will do is they will determine if they believe that even though this is here, should we grant you the services? This is an administrative decision. Like I said, it's often called character of service or character of discharge, and it's done by the Veterans Administration. It's triggered when you first apply for benefits, or if you subsequently apply for benefits, it can be triggered again. Normally they would say you apply the first time and they deny you, and then you apply again for some other benefit and they deny you. Well, you would be able to, provide additional evidence at that second time to show why you should receive the benefit of the doubt from the VA and get the treatment or the benefit. Often, like I said, if you have another honorable, you'll be turned away from a VA healthcare center, and they don't do proper. A lot of times, they don't go through the proper process, and that's one of the reasons that we're here, is to try to help people, gain the benefits that they need. You can also overcome an other than honorable discharge by what's called the insanity exception. It's insanity in this case does not mean the same thing as you think. It just means that you were suffering from some type of mental disability at the time. Another option for overcoming an other than honorable is to apply for what's called the discharge upgrade, which takes your discharge and makes it the government can grant you an upgrade, say from other than honorable to general, and they would issue you a new DD 214 that says general discharge or even honorable if that's the case. But it can be changed at a later date. So you can also, if you have a previous honorable discharge and you completed the initial term of service on that discharge, you should be able to overcome an other than honorable. There are some people who were in the military, they did an honorable tour, they got out, didn't like civilian life so much that they re-enlist or they join back up, and now they have another, it's a new term of service. So if you had a problem during your new term of service, but you had a good old term of service, you should be able to receive health care and overcome that other than honorable. There are some statutory bars, which is written into the law, that say you cannot receive benefits if this happened. Not supposed to be able to happen. If you are a conscientious objector and refuse to fight or go to war, denied. Sentence of a general court martial, if you've been sentenced, denied. Resignation by an officer for the good of the service, which means rather than boot you, they gave them the option to leave. Kind of like you can quit or be fired. If you were a deserter, no benefits. Or if you were absent without leave for more than 180 days. So that, though, is rebuttable, but it's a little bit more complicated. So you can rebut some of these. There are regulatory bans, which means that they are written into the Code of Federal Regulations, and they include, they basically anything that any of these factors are considered to be dishonorable for VA purposes. Accepting a discharge, an undesirable discharge in lieu of court martial. That's that's the base. That could be a basis for denial. Mutiny or spying, obviously that should probably be a basis for denial. Inoffensive moral turpitude, and basically generally it's a conviction of a felony crime. Willful and persistent misconduct. There's some room to work with that one, and homosexual acts involving aggravating circumstances. So overcoming those bars, like I said, under absent without leave for more than 180 days, you can show mitigating factors. Maybe something did happen in the veteran's life that they needed, to be gone, and they could not, and they had a good reason. It's very difficult. Proving the misconduct was not willful and persistent. Say it was a single, maybe the misconduct was a single incident and somehow they label you as a willful and persistent misconduct person. You can fight it and possibly overcome it that way. And if the veteran was suffering from a mental condition at the time of the commission of the offense leading to their discharge, court-martial or resignation. This is what we call the insanity exception. This is the suffering from a mental condition when you did the bad things. A lot of times people would say PTSD is very prevalent here. It's one of the mental conditions that leads a lot of soldiers to that end. Okay. If the VA determines that a veteran, this is insanity in the charge of character of discharge process. If the VA determines that the veteran is barred from the benefits due to misconduct that resulted in an other than honorable discharge, the veteran should be evaluated by an attorney to determine whether they fit the insanity exception. And by that, insanity means due to a disease, the service member experiences a more or less prolonged deviation from his normal method of behavior, or interferes with the peace of society, or has so departed, become antisocial from the accepted standard of the community to which by birth and education he belongs, as to lack the adaptability to make further adjustment for societal customs of the community in which he resides. Whew, that's a lot. So basically, you have to be suffering from a mental condition that causes you to have a change in behavior, a break from reality, something of that nature. PTSD is, like I said, is common here. There's several different types of PTSD and different traumas. So we'll move on from there. Healthcare and the other than honorable discharge. Most veterans with an other than honorable discharge still receive VA healthcare services and for their service-connected disabilities. Your service connection would mean that you would have to have incurred the injury or disability during the term of service. So if you just had, a broken arm that you broke playing baseball, you're not going to get free healthcare for that. But say you had, you blew out your knee in the military and you had to have surgery and you're having bad effects later, that would be something they might cover, that they should cover. Like I said before, service-connected healthcare eligibility of certain persons administratively discharged under other non-honorable conditions is provided. You can still get healthcare for service-connected injuries. That's the one important thing. If the veteran has an other than honorable discharge service-connected disabilities, during the first period, it can be treated with some exceptions unless the veteran has an injury from a period that ended with a bad conduct discharge. There's going to be no medical care if you had a bad conduct discharge. If you meet one of the bars in the previous, the previous slides in the 312, there's going to be no medical coverage. The VA will determine service-connected and in the line of duty with the same standards as any other veteran, as if there was no bad conduct discharge, or if there was no other than honorable bad discharge. The problem is this is when you have an other than honorable, it can be difficult for the veteran to get health care. A lot of times they get turned away, even in denied, and a lot of times it's due to poorly trained VA staff. And that's one of the reasons why veterans come seeking legal help is to access these benefits. Even though they have an other than honorable, that doesn't mean they're necessarily prohibited. So earlier I mentioned that you can upgrade your discharge. What that means is that if you have an other than honorable and you have some explanation as to why you have another, why that conduct shouldn't be looked upon as badly as it was, and why you should have gotten a higher discharge or a higher class of discharge, you have the right to appeal to the military, not the Veterans Administration. You can appeal to the military, the branch of service that you served in, to upgrade your discharge. Each branch operates what's called the Discharge Review Board, and they also have something called the Board of Correction of Military Records. The Discharge Review Board is for people who were discharged less than 15 years ago, and they are seeking a discharge, seeking an upgrade. The Board for Correction of Military Records is for someone that was discharged more than 15 years ago or has exhausted all other remedies that are available. So say you went to the Discharge Review Board and you were denied the process. There's actually a couple of chances that you can take a couple swings at the ball here on this level, and if you miss, then you're allowed to move forward to the Board of Correction of Military Records. These are panels of military members, and they vote and decide whether or not, based on evidence, whether or not you should have your discharge upgraded. They use both of those two use similar standards to determine when they should give you grant you relief, like an upgrade. They evaluate each case individually and determine whether the discharge was legal or if it was fair. There's two standards there: legal or fair. Sometimes the discharge, maybe it didn't violate the rules at the time you were in the military. So there have been times when something was later added and someone there's an out of time issue. The Discharge Review Board uses equity and propriety, while the Board of Corrections uses error or injustice. It's basically the Board of Corrections for Military Records is a little more strict. It's a little harder at that stage. They're looking for clear legal problems or something that's just extremely unjust. Maybe they felt that somebody was discriminated against or something of that nature, and they will fix it or try to fix it. If successful at either of these two, you will be issued a new DD-214, your discharge document, and it will have it will read your new discharge status or your new character of service. The strongest cases for upgrades are the veterans with PTSD or traumatic brain injuries due to combat exposure or military sexual trauma, and veterans who served honorably other than a relatively minor offense, such as testing positive for marijuana, which could and does lead to other than honorable discharges. Okay, so what types of benefits are available from the VA? We've discussed, the eligibility requirements. Now, what can you get? The VA, one of the biggest things is what's called service-connected disability pension, and we'll discuss that here shortly. There's also the the VA pension, and under that, there's a couple of programs called aid in attendance and housebound. There are also things for spouses or widows, and that can include spouse and widows also includes minor children and sometimes parents of veterans. VA does provide burial services under the Cemetery Administration, the GI Bill, which is educational benefits, and the VA also offers home loans with particularly decent terms and better terms in terms of like down payment and things required to veterans. So those are among the benefits. And like I said, we're going to discuss these a little bit more in depth. Disability compensation, and like I said, it's also called service-connected disability. We're going to discuss a little bit about the rating procedure and some other conditions that to take into effect. So, criteria for service-connected disability. The rules say that service connection connotes many factors, but basically it means that the facts shown by evidence established that a particular injury or disease resulted in disability that was coincident with service in the armed forces, or if pre-existing such service was aggravated therein. This may be accomplished by affirmatively showing inception or aggravation during service or through the application of statutory presumptions. Each disabling condition shown by the veteran's service record or for which he seeks a service connection must be considered on the basis of the places, types, and circumstances of service as shown by the service records, the official history of each organization in which he served, the medical records or his medical records, and all pertinent medical and lay evidence. Determinations as to service connection will be based on review of the entire evidence of the record with due consideration to the policies of the Department of Veterans Affairs to administer the law under a broad and liberal interpretation consistent with all the facts in each individual case. What does that say? It says a lot, really. But what it breaks down to is the veteran is suffering from a disability that he incurred or that was, if he had a pre-existing condition, was aggravated during military service while he was on active duty. They're saying that it can be established through direct evidence or a presumption. And a presumption is basically that, a presumption is that it is presumed, they take it on face value that this is related to your service. The VA must consider all kinds of evidence when you submit a claim. That includes medical records. It can include, statements from other people, statements from fellow, like platoon members if they were there when the accident or the injury happened. It can be a statement from your parents of how something changed you. It can be anything. I mean, there's very wide ranging. And they're supposed to take all of this evidence and they're supposed to look at it. And they're supposed to look at it in the light most favorable to you. So they're supposed to be looking at it as if you deserve this. And then they got to figure out why you don't. They got to give you the benefit of the doubt. So the standard that they use to establish direct service connection to an injury or disability is that you have to have a current diagnosis of a disability. So you can't just say, well, my back hurts. sorry about that, you have to have basically some medical evidence that shows that you've been treated for injury, that there's something there, a letter from a doctor, treatment record, something. And then record of in-service injury treatment while on active duty. You have to show that this happened while you were on active duty. Now, active duty doesn't mean that you were working. Active duty means that you were in the military. You were, it's not while you were like working at the post. So if you hurt your knee playing basketball when you're not working, but you're in the military, that's a service-connected injury. It sounds crazy a little bit, but once you're in the military, you're in the military. And then you need medical evidence that links the injury that you had in the military to the current disability. So basically what they call it is a Nexus Letter, which it's normally a doctor who says, this injury is why he's now suffering this problem. And that's actually probably, I mean, if you don't have any of these three, you're going to fail. But a lot of times the most common, I think, failure is that they don't have a good Nexus Letter or a nexus. They can't show the nexus. Now, we talked about PTSD, and it has special considerations. Their service connection for PTSD is established under several different ways. You have to show that there's a diagnosis of PTSD, that there was an in-service stressor, and that there's credible evidence supporting that the in-service stressor occurred. So if you say something happened in Fallujah and that's what caused it, there has to be some type of credible evidence supporting that that whatever stressed you happened in Fallujah. So when I said these can be things like reports from incident reports, or logs from military military units. It could be letters from buddies or from people who were there with you and might have saw what happened. But those type of things, those are the three things that you have to show when you're dealing with PTSD. Now, we talked about pre-service injury, that it gets aggravated. So a pre-existing injury, say you blew out your knee before you went to the military, but it was okay, and you went into the military and you were fine for a while. A pre-existing injury or disease will be considered to have been aggravated by service where there is an increase in disability during such service, unless there is a specific finding that the increase in disability is due to the natural progress of the disease. So if you are suffering from something that is naturally going to get worse and worse, and you can't show that the service or the military caused that to get worse, you can be denied. Your disability claim can be denied. So it's got to be, but they have to show clear and unmistakable evidence that that's not due to natural progress of a condition. Let's see. And again, it does not allow for connection for usual effects from medical or surgical treatment. So if there's something that's a common problem after a surgery and you have the surgery, they're not gonna necessarily buy that it's aggravated. Okay, within the definition, they talked about presumptive conditions. A presumption is basically the military has recognized throughout time that some things that have happened to people while in the military have caused serious problems. Among those is such things as Agent Orange. During Vietnam, they used an herbicide known as Agent Orange to try to deforest parts of Vietnam to knock out the hiding places for the enemies. And it just turns out, I mean, it doesn't just turn out, it turns out that the chemicals in the Agent Orange caused a lot of different seriously bad health effects. Another example could be you worked at a military base where it was later discovered that there was a serious problem with the water system or the water reservoir, and a multitude of people have been ill. So the government has said that, you know, if you suffer from a list of conditions that we know are caused or possibly caused by this condition that we had, the water condition or the Agent Orange, that we're going to assume that Agent Orange or the water caused your problem. So you're going to be, it's called presumptive connection. Like they're not going to, it's not as hard to show that, you know, that you're not going to have a hardest fight to show that, or you shouldn't have as hard a fight, you probably will, that condition is related to, that's related to your service. And like I said, there are a myriad of things that they have recently that they've added. There are continual, they've continued to add things. Recently, there's been some discussion and talk about adding some conditions from the Gulf War syndrome conditions to the presumptive list, just because they've realized that there was something that happened, and you know that's what they need to do. So there are other regulations that you can consult, but each of these presumptions is spelled out by the military, and the conditions which they presume can be caused by them are also pretty much listed. If you have other conditions, you can still, you can always make a claim, but you're going to have to prove up the connection. You might not get a presumptive connection. There is also something called a secondary service connection, and what that is say that it's an injury that is caused or is aggravated by your primary condition. Like if you have a knee problem and you start favoring your leg, and if your right knee is bad and you start favoring and putting more weight on your left leg, and your left knee or your left ankle starts to deteriorate and starts to have problems, there's probably a likelihood that these two things are connected. And so you can claim under what's called secondary service connection that injury is related to your other injury, and you should get service connection for that injury as well, which happens quite a bit. I mean, the human body does compensate and use different things, so there's a high possibility that something like that can, you run into these things. There's also diseases that cause other issues, so they could be secondary conditions. Okay, so once you have submitted your claim and say the VA says, yay, you're disabled, and what they do is they have to rate your disability, and how they do that is based on the severity of the injury or the severity of the disability. The ratings go from 0 to 100, and they're in increments of 10. And there is a very, very large book of how to rate these these disabilities and the injuries. And the ratings are a point of contention. People often think that they're underrated, that the VA is finding the severity too low, and that can be appealed. You can go in, you can file an appeal or file an appeal with the VA and provide evidence and show why they're wrong if you can, and that you can go back in and try to get your rating raised. Ratings can fluctuate, and they do. Some ratings won't be reduced. If a rating can't be reduced if you've had it for 20 continuous years, and the only way they can reduce a 20-year rating is if they claim there's fraud. Probably not going to happen. There's protection for ratings of 10 years or more from being taken away, absent a finding of fraud or that you weren't ever eligible for the benefits. And if the rating has been in effect for 5 years or more, the rating cannot be reduced unless the VA has documentation supporting a permanent improvement in your condition. So I don't know, I'm trying to think of an example, but I don't know. But if somehow you got better, not worse, and the VA finds out, or they have a reevaluation or something, and it's found that you're actually doing much, much better, they can reduce or sever your rating. And why is the rating important? Well, the rating is the percentage is how much money you'll get from the VA based on a monthly amount, the compensation that they're willing to pay a veteran for, a disability. So as it shows here, 100% monthly disability compensation would be $3,000, or as of right now, would be about $3,057.13 a month. And as you go down, it doesn't go down. It's not like that's 100%, 90% is 90% of that number. That's not how it works. They lower the percent. The percentages don't. It's not a percentage of the max. It changes. So 10% is only $140 a month. Whereas if it was a percentage matching that, you would expect 300, but it doesn't work that way. The VA's math is not clear like that. You can sometimes these numbers can change. It just depends on your family composition. Like I said, once you've been rated, if you don't agree with the rating, you can challenge the rating. You can apply for an increase. The VA is going to evaluate you and look at the evidence. You have to provide them medical evidence showing that there's a increase in the severity of your disability, basically. The VA can reevaluate a veteran's disability for appropriate rating. This can be triggered for several different things. I mean, if you apply for other benefits, this may trigger the VA to actually go back and ask, look for a reason to lower this benefit. If they do decide that they're going to lower your benefit or change your rating, they have to give you 60 days to dispute it before they do the change. And if you dispute it within 30 days, the VA will continue to pay you the higher amount until the dispute is resolved. Okay, more on ratings. There is something called combined ratings, because a lot of veterans don't have just one disability. Maybe you have a knee, maybe you have a shoulder, maybe you have an ankle, and each of those is rated separately Your knee would, say your knee is 10%, your shoulders 20%, and your ankles 30%. Now, to you and me, we often would add that up as 10, 20, and 30 and come up with 60. That's not how the VA works. VA math is not good. Basically, what they do is, there's a table, and they take your highest disability, and you go across the table, and you go with the next disability, and you figure out what that is. And then you take that amount, and you go to the table, and it's really complicated, but it's not, like I said, it's not, you don't get 100% disability just because you have 10 things at 10%. Doesn't work that way. So the example here is the veterans rated at 60% and 40%. They would receive a total rating of only 80%, according to the tables. And there's some instances where even if your rating is increased, your benefits don't go up. It's a numbers issue. How the numbers fall on their table. Okay. So we've talked about eligibility for benefits, and say you're eligible and then you do something that makes you ineligible. What things can make you ineligible? Well, going to jail. Service-connected disability benefits are reduced to 10% rating if someone is incarcerated for more than 60 days for reasons of a felony. No reduction of misdemeanors or for being on community control or work release. But if you're in jail for more than 60 days, you're going to get your benefits reduced to 10%. If you have a VA pension, which I will talk about in a little bit, benefits aren't payable during any incarceration more than 60 days for any reason, which includes misdemeanors. So you don't get any money off the pension if you're in jail. And there's actually a kind of a good reason for that, but I'll talk about it a little bit. Fugitive, if you're a fugitive felon, if you have a felony arrest warrant out for your name, and the VA finds out, you will not be eligible for any benefits during that period until you resolve your warrant. I can imagine times when people don't know they have a warrant, and it actually, it can cause problems for you. So don't go to jail and don't commit crimes and get warrants, and you should be okay. So there is something called total disability and individual unemployability. It's called Tdiu. And it exists when a disability or combination of disabilities render it impossible for the average person to obtain substantial gainful employment. Okay. This does not need to be permanent, but it can't be just temporary or something that's not serious. It has to be long-term, and it has to be there. And it has to be, significant impairment. It's also known as individual unemployability, and also exists when the combined rating is 100% or greater under the VA math. Like I said, it includes permanent total disability. Exists when 100% rated impairment is reasonably certain to continue throughout the life of the disabled person. So, if it's something that's going to be there forever, they're going to just consider it a permanent thing. There is a caveat here. A veteran-rated Tdiu will receive payments of 100%, which is the $3,500 or $3,057 rate under the following circumstances: that one or more of their service-connected disabilities is 60% or more, or two or more of their service-connected disabilities with at least one of 40% and a combined of 70 or more, and they have an inability to perform substantially gainful employment. This is more about employment. This is very similar to like disability, Social Security disability in a way. It's just through the military and through the VA. Okay, I mentioned earlier that there's such a thing as a VA pension. VA pensions they're not, when people say pension, they're not really this isn't really what they are, what they think about. To be eligible for a VA pension, it's also known as a non-service connected disability pension. Veterans, must have been discharged under the other than dishonorable condition, served a minimum required of active duty of at least 1 day during an eligible period of war, and is permanently disabled or a patient in a nursing home or over the age of 65 and meets the VA income and net worth requirements. The net worth requirements are very similar to Social Security's SSI. You have to have very low income and very few assets in order to make this. Very difficult. I know in our area, it seems like a lot of people don't, a lot of people are out of this range, but I know it is, there are people out there that could get it. Under this, there's also a couple programs available to veterans and dependents who get the VA pension. If you get the VA pension, you're also entitled to you might be entitled to what's called aid in attendance. And this is when a veteran, you require the aid of another to perform personal functions in everyday living. It's basically you need like an aide or a assistant, living assistant. VA will increase the amount of money paid out in the pension to help cover the costs of the attendant. It's a good bonus. It's a good perk. Although it's not really a perk because you have to qualify for a pension, which mean you don't have hardly any money. And there's also housebound, which increases the pension amount of the veteran when the veteran is substantially confined to their immediate premises due to permanent disability. So if the person cannot move or cannot easily get around, is bedridden, they can also get an increase in their pension. And in order to get either of these, obviously you're going to need medical records and evidence to back up the claim. Also available, spousal and widow's benefits, something called DIC, pension and apportionment. I'm going to talk about DIC primarily. This is available to surviving spouses and eligible children when the veteran either died in the line of duty or died as a result of a service-connected disability or died as a result of a non-service-connected injury and who was totally disabled from service-connected disabilities for at least 10 years, for at least a 10-year period immediately preceding death, or since separation from active duty for at least 5 years immediately preceding death, or at least 1 year immediately preceding death if a former POW. Now, dependency and divinification compensation, which is DIC, which is a benefit that pays a basic monthly rate, and it pays $1,319.04 with some additional allowances. It's basically, it's an extra source of income available to spouses and surviving children. It's by no means a windfall. And just for the record, any of these rates that the money amounts I'm mentioning do vary. They do get updated from time to time, and I believe these are the current numbers as of the date of this presentation. There's also something called the widow's pension or survivor's pension. It's formerly known as the death pension, which is morbid. Deceased veteran must have served during a wartime period, and the widow's or applicant's income must be below the pension rate, and applicant's net worth must be under the Medicaid standard, and applicant must be unmarried, surviving spouse, or marriage ended prior to November 1, 1990 if remarried. Unmarried children of the deceased veteran who is under 18, became permanently disabled before 18, or is 23 but enrolled in an approved educational facility. And this pays basically just a small amount of a benefit to supplement a survivor. It's a very small amount, and like I said, it's available. These are also sometimes available to parents of veterans if they're eligible. Other veterans benefits that you can apply for, generally that we don't deal with too much, the GI Bill, you apply through through the educational services, burial services that generally goes straight to the cemetery. And if you were to run into a problem with these, you could always come to legal aid and we could try to help you with them. And the eligibility for VA home loans is also there. So what other services do we offer at legal aid? Well, or what do we offer? We offer help with discharge upgrades, that's for sure. Assistance with filing a claim for benefits available from the VA. So if you have an injury and you want to become service connected, if you are a spouse whose husband, you want to try to get the DIC or a pension or something of that nature, we can assist you with obtaining benefits if your claim was denied. So if you need to appeal the claim, that's there. Civil legal assistance. We also provide civil legal assistance for matters such as small claims court, consumer issues, eviction or foreclosure, other public benefits, and bankruptcy. Currently, we do not do child support or family law through our program. However, we sometimes can place people with pro bono attorneys, but there are other requirements for that. And also every year we have had, for at least I believe the last 10 years or ish, we've had a Wills for Heroes program, which is normally is in November near Veterans Day. I believe it happened last week, where people can get basic estate planning information, wills and powers of attorney, healthcare surrogates, living wills, things of that nature, so they can prepare for end-of-life situations. Resources that are available for veterans, there's the Florida Department of Veterans Affairs, VA Medical Center, the Collier County Veterans Center, Veterans Services Officers through the VA, Disabled American Veterans Organization, American Legion. There's the Wounded Warriors of Collier County and the Collier County Veterans Council are all out there. There are a number of organizations. If you reach out, if you reach out to the United Way through their 211 number, they can probably also connect you with even more that I can't even name. And so there are available resources. You just have to reach out for them. We don't know you need help unless you reach out to us. So with that, these are just a quick review of some of the places that I got information from. And I'd also like to thank James Heaton from Broward, the Legal Aid Service of Broward County, which is our sister organization, for providing a lot of the information that went into our slides. And I'd just like to thank you for coming or viewing this. We couldn't do this without support from different organizations, particularly the Community Foundation of Collier County, the United Way, the Collier County itself has helped us with different projects. There's a myriad of other organizations, and I'm not trying to slight anyone by not mentioning them, but there's just so many out there, including the Florida Bar Foundation, which provides grants, And I plan on presenting again in the near future on more about how the claims process actually goes through and the steps involved and what you do when you're denied, if you're denied. But this was an overview of what's out there for veterans to possibly claim. And like I said, we're here at Legal Aid, Collier County. If you live in Collier County and you need some assistance as a veteran, please reach out. If I cannot help you, I will try to send you to the person who can. I am currently the only, at least at our organization, or at least in the Collier County branch, the only Veterans Administration, the only VA certified attorney. So if you have anything, please reach out and have a nice day. I thank you for attending or watching.